logos in my presentation because you all saw the K&L Gates logo when you walked in the room. I'm a trademark attorney with K&L Gates. My name is Britt Anderson. And one of the things that you may be wondering, what does a trademark attorney do? Once you have your brand and you have your promotion plan, and maybe even before all of that is put in place, what a trademark attorney does is put the legal backbone into all of it so that when you want to stop somebody else who is using a trademark which is too similar to your own in a related area, or somebody wants to stop you, you have the basis to take all the right steps. And that isn't just purely a reactive approach that a trademark attorney takes. What a trademark attorney does is a trademark thinks many times years and years in advance about where a brand or a trademark is supposed to be in terms of strength in order to put the fences up, to put the foundation in place so that the brand can grow and expand to where it should be, or where the vision of the business person is. So with that introduction noted regarding what a trademark attorney does, let me give you a basic tour of trademark law so you can fit some of the branding and promotion in place. First of all, what is a trademark? It's a word, name, symbol, or device. That sounds like a very obscure statement. Basically, a trademark can last forever if used and protected. It's different than a patent that has a fixed term. A trademark is a completely fungible concept. It's very, in a lot of ways, it's very vague. You don't know what the trademark is all about, and I think that Thomas and Jenny gave a good sense of that. There are a lot of the specifics associated with trademarks often are more difficult to pin down than other kinds of IP, but it's a type of intellectual property that can be stretched and moved into different areas. A trademark can be expanded into different kinds of products, different kinds of services. A service mark is the same thing as a trademark. A trademark has to be capable of identifying a source of a product. It basically is between the consumer and between the producer of the good and service. So a trademark cannot be the name for a generic good. Let me give you an example of that. The Sony Walkman at one point in some countries in the world was considered to be a generic term because it basically there was no suitable replacement for that term because there was only the Walkman product, and people who were walking around with a Walkman were considered only to have that generic product. So that's how, now Sony had to battle that out in different areas of the world, but that gives you an example of how that works. So that's why it's often said a trademark should always be used as an adjective and not as a noun or verb. Of course, there are lots of different points of view. That's somewhat of a controversial statement, but in any event, that's what a trademark is. So trademarks can be almost anything. They can be all kinds of product configurations, words, design marks. You saw a whole bunch of them. Jenny showed you all kinds of different logo designs and things like this. They can be smells, they can be sounds, so forth and so on. Really, it just is that identification between the producer and the consumer's perception of the source of the goods. If you see this symbol, basically it doesn't have any real legal significance at all. All it means is that the person who places the TM on the trademark has claims to have a proprietary interest in that term as a trademark. But it doesn't mean that it's registered necessarily. It may mean that there's a pending application. The trademark could be registered, but sometimes companies decide to use the TM instead of the registered R, just simply for editorial reasons. It could put third parties on notice of a proprietary interest. The circle R symbol in most countries means that the trademark is registered in that particular country. So this is something you get the right to put on once you get a registration for the trademark. Let me give you some ideas of what brand values have brought some companies. These are the companies that are at the top of the Interbrand list, and there are several different lists of these top global brands. But here what you see is two different brands, Coke and Apple. Coke has been at the top of this list for a long period of time. And one aspect of the Coca-Cola brand is that Coca-Cola continuously enforces its rights in the food and beverage segment, in the hospitality segment, by sending out investigators who spot instances where servers in restaurants are passing off Pepsi as Coke. And they've done this for many, many years. That's an example of what they do in order to continue to retain the brand value associated with the trademark as it's articulated by the consumer. One of the things that Apple does is Apple aggressively polices its designs, which include all kinds of different permutations of Apple mobile devices, and also aggressively polices iPrefix product names. So these are some of the things over the years, and actually Interbrand has specifically noted both of these things over the years as aspects of these brands' strategies. So how do you get trademark rights? First of all, in the United States, you get trademark rights by using the trademark. You don't actually have to register or apply to register the trademark. You can just get the trademark rights by using the mark. And that's the same way in a lot of the British Commonwealth countries too. The problem is in most of the rest of the world, and now we're in a fully global economy where, you know, instantly particularly when technology startups in Northern California come out with products, they often have a global marketing plan immediately, at least a global production plan. And so the problem is that it's in most of the rest of the world, it's first to file. So in other words, you actually have to file for the trademark in other countries. And there are some countries in very important jurisdictions, like as an example in China, it's very, very critical that you think through your filing before you even announce what your trademark's going to be. And a lot of brands have gotten into a lot of trouble around the world. Nonetheless, even though you only have to use the trademark in the United States in order to get rights, there are lots of different reasons to register trademarks in the United States. First of all, it provides public notice, because people, when they see that you have a registration or a pending application, then they tend to look at your trademark and consider that you may make a claim against them. You also get, something that's very important, is that when you register a trademark, you get a nationwide right to use that trademark in the United States. If you don't register a trademark, then you may be restricted geographically to one state or to just a collection of states. And there are a variety of other benefits you get as well. So when you get into disputes, and you're probably familiar with all these search engine brands here, and this, in fact, actually is a real website. What you get into is what do you actually do when you get into a dispute, and how can you really plan for all these problems you're going to run into? And you can run into a lot of different kinds of problems. Fortunately, most of them are a little bit more straightforward than this. So what do you really decide to protect? You have to use, and there's lots and lots of different nuances here, and every situation's a little bit different. And I'm not going to give you the usual disclaimer of this is not legal advice, it's only information, etc. But the fact of the matter is that everything is very individualized. But you have to use, when you think about trademark rights, even in a relatively straightforward jurisdiction like the United States, you need to think of a multi-layered approach that has lots of different parts to it so that you can protect your brand over the long run. And that's how we as trademark attorneys, that's how we work to build the fences and the foundations for a brand over a long period of time, is by putting in place different kinds of protection. Word marks, design marks, registered copyrights if possible. Interestingly, a lot of those logos that Jenny put up, despite the extensive work and thinking that goes into those logos that consist of words and shadings and permutations of colors and things like that, may not be registrable as copyrights. So you need to think about trademark protection. How are you going to protect them? How are you going to use them and things like this? Every country is a little bit different. In China has been Since 2003, there have been more trademark applications filed in China than any other country in the world, including the United States. And there are some specific reasons why that's the case in China. We do an extensive amount of work in China in protecting brands and building strategies and battling in disputes in China too. And there are some specific reasons why the trademark protection environment is very specific to China, and you need to take that into account, just like you need to have a somewhat different strategy in the United States. You also need to think about who you're working with internationally. All those things are important for IP protection. You can't let your IP get out of control. You have to restrict people in terms of if they're your partners or franchisees, et cetera, in terms of what they can do with it. The trademark registration process, I'm not going to go into this in any terrific amount of detail. The point is that it takes about 1 to 3 years. It's actually not very expensive to do. It can be, if it's well thought through and articulated at the same time that you think through your branding and you think through what you want to communicate. If you do it up front, it's relatively low cost, even on a fairly broad global basis. So you can get a lot of things out of the way. If you don't think about it up front and you don't get protection in certain countries of the world, you can be in for a lot of expense in terms of trying to control it later on and to get your brand back. So selecting trademarks, there's just two main ideas, and we can basically break those down into two areas. One is, if you have an idea for a trademark and you want to use that for your product or service, basically you need to think of, is it protectable? And the second thing you need to think of is it available? There's really nothing else. As far as protectability goes, there's a sliding scale of trademark protectability. At the end toward me are trademarks which we consider to be strong, and at the other end are trademarks which are generic terms. So that's basically the sliding scale of protectability. The problem is that in a lot of ways, the trademarks which are most attractive and have the greatest appeal to consumers are those trademarks which actually describe the product. So we find a lot of times, particularly in the technology industry, that our clients are very interested in getting what we call highly suggestive trademarks, trademarks which are right on the brink of being descriptive terms. Descriptive terms, as an example, Sports Illustrated or chapstick, are great terms. Once you build the value in them, they're fantastic because you basically define the category in a lot of ways. On the other hand, the problem is that they're teetering right on the brink of disaster. So really what you need to do is you need to constantly work to protect those terms and to keep other people from using them, and also to educate consumers in a lot of respects, because consumers are very apt to say, can you go in and get me a chapstick, when really they don't really care whether you get chapstick brand. They may really think that you're going to go in and get something from Burt's Bees or one of the other 16 brands of lip balm that happen to be in Walgreens. So positive and negative with descriptive marks, and a lot of companies prefer them. You need to have, in order to, initially out of the box, when you first apply to register, if you have something which is a descriptive term, you're not going to be able to get a registration for it. You need to show advertising and promotion over a long period of time in order to build rights and in order to be able to keep people out, which is what obviously these two brands right here have done over a long period of time. So again, and that's the segue really, because descriptive marks are teetering right at the edge of disaster, and the fact of the matter is that trademark rights are indefinite. Trademarks can last forever, but trademark rights can be lost. And so when you think about what you're doing to protect your brand, you need to think about the very basic legal requirements for making sure that you don't lose trademark rights. One thing that could happen is that third parties start to come in from around you and they start to adopt similar marks for similar goods and services, and your rights begin to erode. And what happens there is what we call the development of a crowded field, where basically everyone is sort of narrowed down to a very narrow area, like the beauty pageant area, where there's a lot of different beauty pageants that are named very similarly, and for some reason or another, everybody's able to distinguish between them, but fundamentally they may have a very blurry association of who does those different beauty pageants. And there are lots of areas like that where you have similar names. One other way in which a trademark can be lost is the the Walkman example, is that the trademark can become a generic term for a class of goods. These are examples of trademarks over time, historically, that were once federally registered trademarks in the United States, but they were lost.